Canada is a place where Indigenous people live and have lived for millennia, and this hasn't always been recognized in our history, as we all well know, and it should be. And so in our water talks, we now begin by acknowledging that we are on the territory of the neutral Anishinaabe and Haudenosaunee peoples, and that the University of Waterloo is situated on the Haldimand Tract, which is a piece of land that was promised to 6 nations that includes 6 miles on each side of the Grand River. And in that spirit of working towards reconciliation and understanding, it's my pleasure to welcome our special guests today, members of the University of Waterloo Aboriginal Students Association, who are now going to share a traditional opening to begin our water talk. Thank you.
We're going to sing some songs for you guys, and we have our special guest, Christine here, who's going to say a few words in the language for you guys. It's an honor and a privilege to be here with you today. This first song that we're going to do for you is the Haudenosaunee Mohawk friendship song that's welcoming you here to the territory and to the land. And the second song that we're going to be doing is a water song called Nibi that was written by Doreen Day, and it's a song for all peoples to learn for the healing and the protection of the water for all people.
Oh yeah.
All right, now it is my truly great pleasure to welcome a longtime colleague and friend, Merrell-Ann Phare, a lawyer and author. Merrell-Ann is former chief negotiator on behalf of the government of the Northwest Territories in their negotiations of transboundary water agreements in the Mackenzie River Basin and negotiating Thaidene Nene national and territorial parks. She's the founding executive director of the Centre for Indigenous Environmental Resources, or CIER as it's sometimes known, and she's worked with First Nations in addressing many environmental issues they face all across Canada. She's legal counsel and advisor to a number of Indigenous and other governments and organizations, and she regularly speaks on topics addressing environmental issues, Aboriginal rights, and governance. Sometimes individual people can make a great difference in the world. Merrell-Ann is one of those people. I'm really pleased and honored that she's going to share her thoughts with us today. Her talk is titled, Water Co-Governance and Collaborative Consent, Working in Partnership with Indigenous Peoples to Protect Water and Honor the United Nations Declaration on the Rights of Indigenous People. And I'm really hoping that that's the same as the one that's on the slide behind me. Is it close? Okay, anyways. Because sometimes they change at the end. In any event, please join me in welcoming Merrell-Ann.
Thank you. So I think all the women who sang those beautiful songs have already left the room. Is anybody still here? Oh, I just wanted to thank you very much for the beautiful songs. I'm deeply honored you would come here and sing for us before the talk. Thanks. And thank you to the Water Institute for inviting me to speak to you. So as Rob indicated, I have been, for about the last 6 years, I was the chief negotiator for the government of the Northwest Territories. At the same time, I'm the executive director of the Centre for Indigenous Environmental Resources. And so I've sort of been on both sides of the issue when it comes to how governments, Indigenous or non-Indigenous governments, see their rights and how to negotiate together to try to come to a solution that might meet everybody's needs. And I, in the process of negotiating some agreements I'll tell you about, it happened all around the same time that the United Nations Declaration on the Rights of Indigenous Peoples was finally accepted by Canada. There were a few other key drivers that happened at that time, which I'll explain. And so I've started to think of the way that some of the people I've worked with have engaged with Indigenous governments as a potential path forward. And I'll share with you why I think that. And you can decide for yourself whether you think some of the stuff we've been working on in the North is getting us partway there, whether it's a model that other parts of Canada might find useful or interesting, or at least worthy of further consideration. But my talk is not going to be really that much on the agreements themselves. If you're interested at all in by the end of the talk on what the water agreements are that I negotiated in the North with my team, you can get them off of the Northwest Territories website, the Alberta website, the British Columbia website. Each of them have the copy because we are all signatories to this, and you can find them there in their environment departments or their water departments or what have you. So I'm just going to give you a little bit of context for these agreements first, and then I'll quickly move beyond the agreement part itself. The yellow there is one of the five, but one of the four big basins in Canada. That's the Mackenzie River Basin. And I always keep those arrows in there because the water flows from the bottom arrow up to the top, to the Beaufort Sea. And the direction of flow of water creates probably one of the first big power differentials when you're engaged in discussions between governments over water, because upstream folks tend to think that they have some more entitlement to the water than the downstream folks. And so you're constantly having to take that into account. And I was working in the area, okay, I will use this and hope I don't hurt myself. I was working for the government that represented this big, huge chunk of land right here. So downstream. And the agreements, what we were doing was, in 1997, all of the agreements, all of the governments that are operating in the Mackenzie River Basin, so that's BC, Alberta, Saskatchewan, Yukon, Northwest Territories, and the federal government, created an agreement called the Master Agreement. And this set out a whole series of high-level commitments that they would cooperatively manage the entire basin together along a set of really amazing principles. I urge you to go find that agreement if you're interested in this. But what they never did was figure out how to do it on the ground. They could never actually get to that level of agreement. When it came down to the specifics, the negotiations fell apart in 1997, so they decided at the last minute to put in a requirement to do bilateral agreements. So on the ground, as the water crosses boundaries, how are we going to actually protect the water according to these big principles in the Master Agreement? And those are called the bilateral agreements. And they were never negotiated. And I was brought in for the government in Northwest Territories to help sort of kickstart the process and get some of them done. And so all of those circles are the boundaries where a bilateral agreement needs to be negotiated. And the ones that have been completed are this one right here. That's the NWT Alberta agreement. This one right here, that's the NWT BC agreement. This one is close. This one is difficult. You can understand why. You've got the dams here and you've got the oil sands right here. This one is close. This one was developed a long time ago. It isn't great, and so we're going to update it. And this one is just one that the NWT wants to offer to the government of Nunavut. They're not technically within, there's just a teeny tiny bit right here where Nunavut is in the Mackenzie River Basin, but they're not a signatory to this original agreement here because they didn't exist in 1997. They were part of the Northwest Territories back then. They separated since then, and so there's a little bit of an anomaly, but the NWT wants to offer that to the Nunavut. And so you'd see if all of these agreements are actually done, you'll have like this massive land part of Canada that's governed by this cooperative management regime. And there's a whole bunch of agreements. You can see there, NWT will end up having the most agreements at 4, plus Nunavut, so 5 agreements. The 2 agreements that I was working on, the one with Alberta and the one with BC, were signed last year. So March and October, respectively. And they're in the process of being implemented. Now, to move on to the subject of, you needed to understand some of that context so you know now what all the complication was and how it relates specifically to Indigenous governments and people in the area. The Northwest Territories is probably the most complicated place in Canada in terms of Indigenous rights, the expression of Indigenous rights. There are settled land claims there. There are land claims that are being negotiated that have been under negotiation for 25 years. There are treaties. There are treaty land entitlement processes underway. So that's trying to deal with unfulfilled treaty promises. There are Indigenous nations who don't accept any of those things, even though they all exist, and they feel they have inherent authorities that entitle them to be at the table. You have like many, and this is one of the maps that you can get off the government of the Northwest Territories website. It's about 10 megabytes, just that one map. It'll freeze your computer downloading it because it's got so many layers. You can't see, obviously, but every single one of these things is a different nation with a different sort of set of kind of rights that they're asserting or dealing with. And one of the things I wanted you to see is when you look down here at Alberta and BC and Saskatchewan here, there's many overlapping lines. Like you have different nations asserting different things over the same territory. And that doesn't even account for what the federal government or the territorial government think about their own jurisdictions. So this is a situation where we had to say, if we rely on what the law says about who has which rights and wait for that to be really clear and everybody to agree, we will never get anywhere. We will not get these agreements done. The safety net that we have, we know, everybody probably has heard of the duty to consult and accommodate, because Indigenous people have rights that are protected under the Constitution. If a government wants to go ahead with something like an agreement or anything like that, they have a duty to consult Indigenous people. But that tends to be interpreted as a late stage kind of obligation almost. And so we tried to pull that way to the front of the process and say, we might have a duty to consult, but we actually want to get to the point where this agreement and all of the things we're doing are co-owned. We believe they're ours as all governments. And so the only way we can do that is if we're all at the table from the moment. All we really know is we want an agreement. We have no idea what'll be in it. We don't even know what we want, anything, but we all need to be there from that very first moment. Now, I need to point out, it wasn't the case that Indigenous governments were at the negotiating table when the first agreement in 1997 was signed. But since that time, the government of the Northwest Territories, at least, has taken a very, very, very proactive role in involving Indigenous governments in how business is conducted in the territory all the time. And I'll give you some examples later on in my slides. But so the message from this slide is just that there's an incredible level of complexity that standard processes will not address. So we had to think of something different. Now, as we were getting to the end of the negotiations, and I'll show you sort of what we did, but as we were getting to the end of the negotiations and what is facing us all now, today, no matter what process you're in, because I'm done those agreements, I don't work for them anymore, and I'm working on other files as all of you are doing your thing, and these are the drivers. The next 3 slides I kind of see as the main things that affect all of the work any of us do basically in Canada right now, particularly when it comes to land and water. One is this statement, which is the commitment of the current government. It's the first time in Canadian history that a federal government has said something like this, that we need a nation-to-nation relationship with Indigenous people. It's our Prime Minister who said it. And that no relationship is more important to him and to Canada than that relationship. So great expectations for what this will look like. And over the last couple of weeks, we've seen I have anyway, I don't know if you guys have seen in the Globe and Maclean's and things like that, some pretty discouraging assessments of whether the current government is fulfilling this, whether they are actually delivering on showing what this looks like. I think there is a solution there, but this is not an easy short-term fix to build a nation-to-nation relationship. And I think we all need to remember that it took us 500 years to get into this situation. It's going to take us a long time of concerted and focused effort to build our way out of it. But the nation-to-nation relationship is a continual driver. The second one is, of course, the United Nations Declaration on the Rights of Indigenous People. And in 2010, Canada finally endorsed it, saying that they are confident, and this was under the previous government, so it was met with some skepticism as what did the previous government mean by this particular phrase, that they're confident that it can be interpreted within our Constitution and our legal framework? Does that mean that it's nothing new, it's nothing additional, and it's basically, the most cynical view would be, we have to consult with Indigenous people when we want to do something. That's all this is. It's just basically saying we need to consult with them, and we'll do that. I think that's what a number of people interpreted this statement as being. I think it is much more than that, but it is still, the United Nations Declaration is still completely legal within our framework of how Canada is structured and how we do business in this country, and I'll explain to you why I think that. The most controversial provision, and it shows up a few places in the Declaration, is this free, prior, and informed consent piece, which is basically saying in a number of ways and in a number of places, but for this discussion, probably the most relevant one is when it comes to decisions that are being made about their lands, and they have the right, they have to have the opportunity to give consent. Like, they need to do that. They need to be engaged, and theoretically, if they don't give their consent, then what? And that's the big issue that you see everybody really kind of getting extremely black and white about, and really kind of polarizing. And I actually think that there's a way through that, which is the bulk of my presentation today. It's this idea of a collaborative approach to consent, where we achieve each other's consent. And I'll talk more about that. I do want to point out, though, that the Truth and Reconciliation Commission did accept, and Canada accepted all the recommendations of the Truth and Reconciliation Commission, that they recommended that all provisions of the United Nations Declaration be implemented. And some of them are pretty significant. The TRC recommendations on UNDRIP basically say Canada should figure out all the laws, all the policies, a framework, a whole structure for implementing UNDRIP in every decision they make, and give guidance to all the departments in all levels of decision making. Is a pretty significant commitment, and Canada agreed with it. They said, we adopt those recommendations. So we are now at the hard place of trying to figure out, how do we do this? We have to unpack these boxes. I think many, many people are in support of the sentiments behind this, but we are all at the either fortunate or unfortunate, depending on how much work you want to do, place of having to figure it out now, having to say, so what do we actually do to achieve a nation-to-nation relationship? What do we actually do to build reconciliation? What do we actually have to do in our day-to-day jobs and in our lives to be able to achieve mutual consent, or consent of Indigenous people? The third decision, and it came at just shortly after, not that long after Canada accepted the United Nations Declaration, was the Chilcotin decision out of BC, which you probably have heard of. It's the decision, the first time in Canadian history, that the Supreme Court acknowledged the actual existence of Aboriginal title in Canada. They had acknowledged that it existed before that. There had just never been a place where they'd actually said, and it exists right here. So that was a huge landmark. In the legal community, we'd wondered for years if it would ever actually be shown to exist, or if it was just a theoretical concept that could exist. It does. So you have title, and the Supreme Court used the consent word. In the legal community, a lot of us are thinking, what is everybody fighting about over this consent thing? Because the Supreme Court said, if you want to do things that might impact Aboriginal title, you have to achieve the consent of the Aboriginal title holders first. The thing is the case, the next sentence, there was one more sentence after that, which said, but if the group doesn't provide consent, then the government can proceed. They have an extremely high burden, though, to show the courts that what they're doing is justified. It's called the justification test. And so you can see in that little bit there, I think, is the path to working with Indigenous people, because you can see the courts are saying you have to achieve consent. That means you have to work really, really hard in a relationship with Indigenous governments to find a consensus with them about a path forward on a decision. At the end of the day, if you dare go ahead without their consent, we will hold you to an incredibly high standard. The justification test is extremely difficult. It's a big, huge, long thing in the courts, and if you want to go look at the Chilcotin decision, they actually tell you all the things the government would have to do to prove that they are still justified in going ahead against the wishes of Indigenous people. So, the very fine point is, technically, under the Canadian Constitution, the government can go ahead without the consent, but the messages coming out of the Supreme Court are so strong that you do that at your peril, that I think any government that did it would get shot down in court. I really do think that they would be told by the Supreme Court, you haven't worked hard enough. You just went, and there's a few hallmarks, I think, of where the courts would say, here's why I think you as a government haven't worked hard enough. I'll show you a few of those in a moment. So people like Tom Flanagan in the Globe and Mail is classic, this kind of stuff, where it's really trying to polarize the discussion and say, if we implement the United Nations Declaration, or if we engage in dialogue with Aboriginal governments on an ongoing basis, we're giving them a veto, and all resource development will stop, and our country will fall apart, and we're overturning the Constitution, and this real fear-mongering, which I think is just a diversion from the very hard work that we have to do to build relationships between governments at all levels, across all governments all the time. And that's actually what consent is about, right? So this is where I wanted to just reorient before I get into this idea that I have about collaborative consent. I wanted to reorient some of our language. And I don't usually veer into stuff like this, but I've had a lot of conversations lately where people, specifically about UNDRIP, have been really wanting to work together. And I just want us all, no matter who we are today in this point in time, my personal view is none of us are colonizers. We inherited a system that none of us created. We have a choice whether we perpetuate that system or not, right? That's the most fundamental choice we face. We are all needing to sort of decolonize our own thinking about what it means to be in Canada and what it means to, what's our responsibility to fix some of these problems. But they are a legacy we inherited. And through our votes and through our things we say and the work we do, we can change that legacy. But I don't want to be a colonizer any more than I want Indigenous people to be in a group called the colonized. It's a separation, and I actually think that most of the people that I work with tend to call each other as allies and partners and collaborators in trying to fix a broken system that we got. And I just think it's a much more empowering language that gives a lot more strength to all the people that are trying to actually do this. So, when we did the negotiations for the water agreement, the first fight we had was within our own system, where at the very beginning, our Department of Justice said, remember, you need to consult with the Aboriginal governments. And we didn't know when to start that. And what we decided to do was start at the very beginning and bring them in a whole bunch of, on the negotiating team, have advisory committees. The government has committees, there's a whole bunch of levels, and we said, but if everybody's working together to build these agreements, why do we need to consult at the end? Like, it'll be agreements that we all support. And that's where we first started to conceive of this idea of collaborative consent. We're constantly negotiating with ourselves at a table and coming up with what we think can work, and we don't walk away. And it seems like a deceptively simple solution, right? Because it really is about sitting and having a permanent commitment to not walking away from a table that you're at. And there's an anecdote from the person I reported to then, who was the minister. Half of the Northwest Territory are made up of Indigenous people. It affects their cabinet, it affects their government. It probably has a lot to say about why they are as progressive as they are in terms of their relationship with Indigenous folks. And he, as minister, was in a meeting with a whole bunch of Aboriginal governments, and on one particularly very difficult topic, one of the governments was just going to get up and walk out. And because in protest of what he was saying, the minister was saying, and the minister said, we're in a government-to-government relationship. If we're committed to this, you can't walk out anymore, just like I can't walk out anymore. Like, we just have to stay here and go around it again and again and again. And if we have to table the issue for another month, we'll do it, but we never walk away. And the Aboriginal government didn't walk away, but I think it was a defining moment for them in terms of understanding the respect each government was giving. So long-term commitments to multi-layered processes is probably a hallmark of consent. And the one bullet I wanted to, the last one about the fettering, I want to unpack that one a little bit for you, because when you're in these tables, say you're able to get through whatever bureaucratic system you've got that is trying to stop you from doing this, because believe me, that will happen. And you're sitting at the table, one of the things that really kind of gets in the way is the constant risk-averse thinking of, and I'm a lawyer, so, of lawyers generally, which is, but we don't know their legal authorities. If we show up at a table with an Aboriginal government without having a clear sense of whether they have the jurisdiction to even talk about this, then we're acknowledging their jurisdiction. We're acknowledging that they have the right to be there, and we're acknowledging, legally at another table that will be used against us. Or we're giving up the power we have. If we say that Aboriginal governments have the right to sit at a table where we're negotiating a water agreement, we must be giving up some of our power over water, our jurisdiction, because otherwise why would we let them be there? We're the ones who have the decision-making authority, right? And that in legal terms is called fettering, where you actually have power and you give it up, and you can't do that legally as a government. That's against, the law for governments to do that. Ministers cannot fetter their jurisdiction. They have to keep it and use it. And so the way we got around that, or kind of reframe that, was to say, regardless of whether we agree with each other's interpretation of our own power, whether or not, I, as the chief negotiator for the government of the Northwest Territories, agree with the chief negotiator for the Acacho government, for example, that they have full authority over water and they own all their land and the GNWT has no right to be there. We don't have to agree on that. That's actually a totally different table. Somebody else will figure that out. What we're here to do is figure out how to protect the water together. And why don't we just agree on what we're each going to do and what our goal is, and how we're going to work together over time, and what capacity we need to get there, and what are the rules we're going to follow in doing that, and can we put that down in a piece of paper, and we'll call that an agreement or a memorandum of understanding or something, but we will move ahead with the thing we want to get done that'll make all of our lives better without fighting about those other things. And my choice to say yes to that process is how I'm exercising my jurisdiction as minister. It's how the chief of the First Nation or the community is exercising their jurisdiction, whatever they believe it to be. We each show up together at a table and agree to work together. And the lawyers can fight it out in some other room, and maybe someday at the Supreme Court something will be made clear. But in the meantime, the water gets protected, right? And the decisions are better. And so that's a big hurdle that we had to get through, and it worked so far. Now, one of the things that I wanted to, I don't know if you've heard any of the current government ministers talk about, I think Minister McKenna is probably the one who's talked about it the most, about cooperative federalism, about the fact that, and the Prime Minister has also, that our country is about, we're a federalist country, and we cooperate to govern this country. You have different levels of government. You have the federal government and the provincial government. They each have different jurisdictions. And they have to cooperate if the country is going to fit together and work at all, right? Because they don't have jurisdiction in the same area. And so you have to have tables, which exist, many of them do, where the federal and provincial and territorial governments come together at the very highest level to set decision-making and policy direction for the whole country all the time. They're called FTP tables, federal, territorial, provincial tables. And they involve usually ministers and premiers and prime ministers. That's who usually sits at them, and they deal with all kinds of things. In the environment section, there's a whole bunch. The Canadian Council of Forest Ministers, the Canadian Council of Ministers of the Environment. There's lots of stuff in every area. And Indigenous governments are never there. And so I've always said, all we really need to do is start that's the table of federalism, the table of confederation. That's how Canada was first created. If we said to ourselves, Indigenous governments are one of the founding nations of Canada, what we have not done is pull up the extra chairs to the table of confederation, those FTP tables. That's what we need to do. We need to bring them there all the time, so that all of these decisions that are normally made by just the non-Indigenous governments, now together we're making decisions. At the highest political level, it's actually a very graceful solution. It's an elegant solution, but it involves a dramatic shift in the mental ideas about power and who can be at tables like that, right? There is some questions also about who would be at the table on the Indigenous government side, and that's a very important question. The Minister of Justice posed it to all of the First Nation chiefs in Assembly less than 6 months ago and said, folks, if we want to implement UNDRIP, you have to tell us who you are. Like, who's going to come to the table? We can't have every single community. We can't have 600 communities, and that's just First Nation. That's not even included Métis or Inuit at these tables. Like, how are we going to organize? How are you going to organize yourselves? But that's a good question to ask, and I was happy that she asked that, because that's getting into the unpacking the box, the meat of this problem. I wanted to point out that this kind of idea, you can see it almost looks like we're getting there, right? First meeting of ministers and leaders at FPT and then Indigenous, and it's a forum, and that's not bad. The problem is that it's not ongoing. It was just a one-shot deal, or maybe once every now and then. Second, you can see, if you can read it, that the ministers and leaders discussed a number of important issues, including UNDRIP and a whole bunch of really interesting stuff, but they just discussed it. They didn't necessarily make any decisions about it. And this is the only stuff that they agreed to collaborate on. Very narrow list. Not unimportant. These pieces are important. But these aren't the things that set Canada's direction, right? If you think about how this country, the vision for our country, and how in an ongoing way we are going to run Canada, making the Federation work for a whole bunch of things, including water and other things, you know, we need consistent, ongoing engagement. So I just want to give you some examples now of where I actually think consent it's actually a non-issue. It's already being done in Canada. So we just need to not be so afraid of it, and we just need to get creative of where we can do it. In the Northwest Territories, they co-draft legislation together. Article 18 of the United Nations Declaration, UNDRIP, on the Rights of Indigenous People, says Indigenous people have the right to be involved in decision making, and 19, I think, says they have the right to consent to legislation that might affect them. So what the Northwest Territories has done is said, why don't we all just get in the same room and write this thing together? Instead of the Department of Justice writing it, and then a department going out and consulting widely, listening, taking all the information back into the dark hole of justice and editing it, and then going out for the process, you know, like it's very internal, external. Why don't we all just get all of our governments and all of our lawyers together in the room and hash it out so we get to a law we all like? Like, it doesn't that make more sense? And we all own that law. We all agree. We will be bound by that. Well, they've already done that. They did that with the Wildlife Act, and they're going to do it, as far as I know, with the Waters Act, Forestry Act, Environmental Rights Act, Environmental Protection Act. Like, they're in the middle of co-drafting all those other laws in the North. We could do that with our laws here too if we wanted to. They do that on policy and plan development too. So when governments create big policies for the direction that the governments are going to go, they do it together with Indigenous governments together. It doesn't happen after. Water governance is the example I will give you in a moment about sharing lands and waters, and then there's specific ones on forestry and things like that, which I won't get into at all here. But at the end of my PowerPoint, there's a website that has a document that I and a colleague of I have written on collaborative consent, and you can download it if you want, and it gives you more detail on all of these examples. But the idea is you don't just focus on engagement at this stage of things. On all things, you're starting both at the policy, program, all the way down to the project level, like all levels, and at all times, not just one specific situation, all situations. And the biggest part we found was this piece, was defining what we care about in commonality and why we care about it, and what are the possible ways to show that we care. That was the most important stage in working with Indigenous governments when we did it on this water agreement. Now, okay, so I'll wrap this up, try and go through this quickly. So the collaborative consent hallmarks, the way you can tell a process that seems to be getting closer to achieving this consent-based, mutual consent-based idea is, first, it would be permanent and ongoing, of course. It's mutual rather than, and ongoing rather than one specific situation. You have undefined but sometimes overlapping or complementary jurisdiction. So First Nations and Métis folks can show up saying, we believe we have laws that govern the use of water in this territory, and the feds in the territory and the provinces can show up at this table saying the same thing. They could, if the lawyers went out on the street, they'd fight about it, but in the room, they're like, okay, so if we all believe this, then how are we gonna each exercise our jurisdictions to achieve a goal we're trying to get? At the end of the day, it may satisfy a duty to consult. You could see at the very end of it, you could find that process unnecessary because we've already achieved agreement. There's no veto, and it's part of the path of reconciliation. The no veto part, I wanted to mention one other thing too, is I actually think we've already all got a veto anyway. It's what we do all the time right now. Like, if we don't get along, we just go sue, or we do public protests, or we do whatever we do when we're deciding that we don't want to play in the sandbox anymore. We don't like what you're doing. You don't like what we're doing. Like, that's no different. I think choosing a consent-based process is choosing a very different path that recognizes we're not going to play like that anymore. We're actually going to behave as governments that all have a right to be at the table. We just have to really commit to getting to a solution that works. And of course, you could see if you did this ongoing in all areas at all times, you would ultimately be reconciling, right? The reconciliation goal would be being met over time. So in the interests of time, I wanted to show you an example, and you can decide if you think this is getting us somewhere based on what I've said on consent. The end result of the agreement, and this is just the governance piece of it. I'm not talking to you at all about what the water agreement actually says in it. But in the agreement, there's a certain governance structure that's set up, the water agreements. And I want to explain to you, and you guys decide at the end of the day how it could be improved maybe. So if you look at the yellow dotted line, and imagine that's the basin, that's like the entire Mackenzie River Basin. The black dotted lines just symbolize the jurisdictional boundaries, so Alberta, BC, NWT, what have you. At that basin level, that master agreement that was created in 1997 created a board of all jurisdictions that sit on it, and every jurisdiction has an Aboriginal government that also sits on that. I think that's the only place in Canada, the only government agreement in Canada that does that. An Aboriginal government for every jurisdiction and the actual jurisdiction itself. So you've got a pretty interesting model right there. The agreement that we signed, that is the transboundary part, has another committee called the Bilateral Management Committee. It also has Indigenous governments, a government representative on it. So you'll have the GNWT and one Indigenous government, and that's our team bringing to the table. So you've seen that flow through, that engagement, and those are decision-making tables. So that's the key thing that you need to remember. This isn't an advisory table. This is where decisions are made on the agreement, and that's the key difference. You need to have representation where decisions are made, not where advice is given, or at least not only where advice is given. Now, if you look at the black dotted line I just said, within the GNWT itself, and so you'd have to ask yourself and look at all the other jurisdictions in the basin and say, are they also doing this? But you have the government itself having interesting structures for partnering with Indigenous governments on how they all do their work. One is the Intergovernmental Council, and it's a council of the GNWT, the Government of the Northwest Territories, and all Indigenous governments. And they set the policy for the territory together in regular, like every 6-month meetings, and review each other's legislation and do that kind of stuff. Like, that's a collaborative governance at the highest level in the North. Within the GNWT, they have environment departments and all departments, and they have structures set up where Indigenous governments do advise them at that level. That's more of an advisory function because it is actually within GNWT. And similarly, Indigenous governments have their folks that work with the GNWT. So you see, you're trying to connect at the technical level, the political level. Now, one final thing on this. The one thing that I think you would have to ask is, do the other jurisdictions in the Mackenzie River Basin also play like this? Do all of these structures communicate well? Like, does this communicate with this well? Does this communicate with this well? You know, across these borders, do they communicate well? Is there any consistency required? If you really want to manage things really well, both for the water and for reconciliation, you've got to continually be focusing on how to improve that. And then, so my final thoughts, my last slide. And these are just big picture ideas that are more for you to think about. They're not conclusions, but they're basically my experience working for 25 or so years in this field is that we are still at a very core level in our relationships with Indigenous people, thinking about the creation of this country as kind of a divorce, your land versus our land. We'll settle your land. That'll then not any longer be our land. You know, your rights, our rights. We would need agreements to do all that and all that kind of thing. To me, that represents a mentality that is about like a divorce rather than a marriage of governments that are here to build a Canada that is good for all of us. And you can see if it's a marriage, you're just constantly working at it, right? Like all the time. Yeah. And so that's actually what I think at all levels, on all things. I actually think collaborative consent can address a lot of these UNDRIP and nation-to-nation pieces if crafted well with open and good intention, commitment, long-term, consistent commitment. I wonder about the big picture on reconciliation. I would love to see something like a reconciliation test where at all levels we ask ourselves, think about even your research projects or think about government policy or think about legal decisions, anything like that. Is the thing I'm trying to do here at the end of the day moving us down the path of reconciliation or further down or further away? Can it, because I really think that many of these decisions affect all parts of our lives, and we could have something like, I for sure think we need it in law. We need to assess government decisions based on a reconciliation type test, but it can apply in any situation. And I've long believed that we're not only reconciling between Indigenous and non-Indigenous people, there's a reconciliation required between all people and the environment and the ecosystem that we are dependent on and live in, and that form of reconciliation is also a critical piece. And finally, just the idea, if you think of all of these pieces of consent, and if you could apply them to all the layers that make up watershed governance, and how nested that is and how big it is, at the end of the day, if we were able to do this, we would be rebuilding our nation fundamentally. Like we'd be doing it from a water lens, but it's about relationships that are needed in all things, not just water. And so I feel like that's an incredibly exciting thing. It's an enormous task. I don't want you to feel hugely overwhelmed, like this is way too big for any of us, but I do think that, you know, at a certain level, it's really just about pulling chairs up to the table, right? And saying, that table's always gonna be here and we're gonna work this through. So it's long overdue, but it would be exciting to get there. So thank you.
Thank you, Merrell-Ann. And I think we have some time for questions. About how long, Kevin? 10 minutes. Okay, so this microphone is for recording. It's not for amplification. So when you want to ask a question, you need to let me know. I will bring you the microphone. You can use it, and then your question will be recorded as well. So who would like to begin? Roy.
Thank you very much. That was very interesting. It reminds me a lot of the role of procedural justice approach, where the process of getting to an outcome is even more important than the outcome perhaps itself. And by involving people, you get much more support, public support for the outcome that whatever the outcome is, there is support for the outcome because you engage all these different stakeholders. And it reminds me a lot of the polder model that we have in the Netherlands, where everyone is part of the process and we jointly try to reach a consent on an agreeable outcome. What I was wondering a little bit, though, was what do you do if you identify irreconcilable interests or solutions? Do you have perhaps some examples of those kind of outcomes where it's really very hard to reconcile these conflicting interests, perhaps?
Yeah. Sure, that's the most difficult question, of course. Well, I mean, you can look at what we do right now, and we could ask ourselves, could that continue to work? So look at what the feds are doing on the carbon price. They have full jurisdiction to do what they're doing. However, they recognize that having the engagement and the support of the provinces and territories is what cooperative federalism is about. We need to do this together. At the end of the day, if the provinces and territories don't agree, it will be imposed on them. But ultimately, what you're trying to do is resolve it as much as you can. So that's one very current, very real situation. And you can see they're basically setting a standard, and then they're going to let the folks figure out how to achieve that, right? So that's one where you have one person just exercise unilaterally their jurisdiction. I mean, the other ways that I've seen it work at FTP tables are, I guess we're just going to table that issue till next year, right? They decide it's not so important to destroy a relationship as it is to go ahead with this issue. And that's how the feds and the territories and the provinces rarely sue each other. When they do, it's over something really, really big. What they tend to do is wait, you know? And sometimes some things can't wait. So you can see on carbon price, it can't wait. So you're gonna go ahead, and sometimes not everybody's gonna like the decision. But I think that over time, if people believed in the process, that you had the tables, you know, federalism tables, everybody was there, over time everybody's going to know sometimes I'm not going to like a decision. And it's just going to, but it's when you're not at the table and then it's imposed that it becomes untenable. Yeah.
Thank you so much for your talk. That was really interesting. I was just wondering your thoughts on like the North in general, but especially the GNWT. I think getting toward collaborative consent, in many areas they've really been a leader, and I think part of that also is because, well, it's new, devolution is new, and the territory is small, so people tend to know each other. And I'm just seeing some other things in Canada, like the recent Muskrat Falls issue on the East Coast, where the jurisdictions seem a lot more intransigent to some of these newer ideas. So I'm wondering if you see like certain jurisdictions as being leaders and others are going to be lagging, and if you see any geographic pattern to that, or what you might predict over the next 10 years.
Well, okay, I don't see certain regions as being sort of, you know, genetically progressive, or, you know, that kind of thing where they just seem more progressive all the time than everybody else. What I have seen is individual leaders be ridiculously brave in trying to do some of this work. I worked for the GNWT as an external negotiator at a time when there was a minister there who was just going to make it happen, and that's what he did, and that can happen anywhere at any time. I mean, that really is electing in the right people who have a vision of change, right? That can get stuff done. I was, and still am, hopeful that the current federal government is like that. They have said many of the right things. I think what you have is many sizes bigger, right? The GNWT has 40-some thousand people in it, the NWT rather. And so, you know, you've got much more degrees of complexity, at least in terms of size federally. But what I'm hoping with some of the things we've been writing about what the North has done is that it's a model that could be extended or applied, and also to show that it has been done, because even though GNWT in the North in general is smaller, they are infinitely, in some ways, more complex. Just the rights issues alone, just going through devolution in the last 2 years, like these things are huge in terms of government complexity, and they still do this process. That's what governments do. You just manage your way through the risk and the complexity. It's just who's managing it, who's at the table. It really comes down to that over and over again.
Thank you for your talk. I just had a question about, two-part question and a comment.
a question about, you're talking about these FTP tables and then including Indigenous people within that. How would that look if it also incorporates Indigenous decision-making processes, right? Because in terms of what I'm hearing right now, it's saying that, you know, you have the power to be at the table, but then you're also being forced to use a colonial system of decision-making. And so what are the other ways of changing that around and actually thinking about forms of decolonization, of how we come to decisions where we're following the first people of this land when we are making those decisions? And then the other part was just to bring to people's attention that there is a constitutional challenge happening November 30th around consent of Line 9. That goes through our region. It's a constitutional challenge because Line 9 Enbridge applied to the National Energy Board to seek consent, and the federal government wasn't involved in that constitutional consent process that we're talking about today. And so that's November 30th, and I'm going to be outside and you can talk to me more about that and all that legal case and what that means for us in the region. But yeah.
Thanks. So that's an excellent point about the process of decision making. My understanding, I've only been as an observer at some of those FTP tables, and they, in theory, are a consensus-based decision-making style. And to the extent that Indigenous governments, and I've routinely seen Indigenous governments and communities use consensus-based styles also. And so I think there's huge room for improvement. The way that the consensus ends up being reached right now is often those FTP tables don't have really difficult issues that they discuss at the actual table, right? They'll leave those off the agenda until next year or till whenever, or they'll leave the officials to deal with it, and it doesn't get to the ministers to actually talk about. And so you have some big fixes that would have to happen, and so it might not even be those tables that are the ones you want. You might have to create something new, but the idea is you have decision makers at constant, like at permanent tables where the big important decisions are made. And yes, all government's officials will work to get all that ready, including Indigenous government's officials, right? You work to find the areas of consensus that the leaders can find, but it is still a consensus style. And even at the end of the day, even with the Indigenous governments I've worked with, consensus doesn't mean a decision never goes ahead. Sometimes it means that, sometimes it doesn't. It depends on the decision. Sometimes it means your opposition or your views have been noted, but you're willing to let the decision go forward even though you don't like it. Other times it means we're not talking about this now for a while. We need to break on this and we have to wait and nothing happens. Other times, you know, it changes depending on the type of decision sometimes. And so, yeah, like I think you've got much more, you have to be able to handle a lot more complexity if we were to really do this. But I think it's needed, I agree with you, and I think other methods of decision making will be critical to having it be successful.
So I have a question too, Merrell-Ann, and by great good fortune, I also have a microphone, so isn't that a nice coincidence? What I'm wondering is, for the model of collaborative consent that you've been outlining here, I noted at the beginning you began with some drivers, including Tsilhqot'in. The legal landscape is always evolving, and we always seem to be one Supreme Court decision away from another change. And there was a fascinating article in the Globe about the relationship between some of the reserves in Alberta and the provincial licensing system, yeah, and whether or not that would produce a new Supreme Court decision.
Don't you feel a legal challenge coming on that one?
I feel a legal challenge coming, and yes. I guess my question is, I almost wonder, do we want that legal challenge? Like, is more needed, or would more take the relationship you're trying to imagine, veer it back into a place where you don't think it necessarily should be going or wants to go?
Yeah, I mean, I don't think that we need, personally, the Supreme Court has been so clear. 200 cases in the last 20 years on Aboriginal rights, and the vast majority of them have been successful on the favor of Aboriginal people. The Supreme Court has said, we're all here to stay, you guys need to figure this out, it's about reconciliation, blah, over and over and over again. The message to governments could not be clearer. And yes, they're struggling with getting as far down the consent path as they can without truly rewriting the Constitution. But the Constitution protects Aboriginal rights also. as creating the federal and territorial division of powers, right? And federal and provincial and territorial. So I actually think that there's a message that's coming from the courts. We don't need to hear it any more times. What we need to do is actually implement it. And it's implementable. My ultimate message is I actually think it's implementable if we actually unpack the things we want to do, like create laws and create policies and create programs that work for everybody. We can actually do that. That's not to say that legal challenges aren't necessary, like the one that was just mentioned. Could absolutely, at certain points, that's where there's irreconcilable differences, people will resort to the law. That's what it's there for. I just think there's so much that can be done way before that. We resort to that way earlier without doing all of those things that are actually doable and are being done in some regions.
Excellent. Okay, so I see a question here. And just for a quick head count, are there more questions after this one? Okay, so one here and one here. All right.
Hi, thank you very much for your talk. It was very interesting. So with regards to incorporating all the communities that could be affected by any watershed, you had said that it can be very difficult because there may be sometimes hundreds of communities that could be affected of just Indigenous peoples. So maybe, in your opinion, what do you think are some good ideas or maybe next steps to make sure that there's always inclusive and effective collaboration between the governments and Indigenous bodies?
So I think one of the things you can do is ask Indigenous peoples that. And that might seem like a bit of a cop-out of an answer, but it's actually really genuine, because I believe that the creation of the framework of the process, the actual process itself, needs to be co-designed, right? So if we said, okay, we have a watershed governance structure and it involves this board and then these sets of committees and this, and how do you guys organize to fit into our structure? Well, you've already designed a process that may not work for them. And so the question is, it would be, what's the forum that you could create to ask that question? How can we both design a system that we can both fit into at all the levels we need to fit into to achieve a watershed outcome that we're looking for? And it might be the creation of a totally different set of nested structures. Or you might still keep all your structures and I might keep mine, but we have something that overlaps that works together. Like, who knows? But you have to start from that question. And then there will be, the challenge I've found often is just the way we have the Western sort of federal territorial side has really sort of linear nested systems that one within the other, and they, from the bottom up to the top. And many Indigenous governments have many fewer layers. There'll be a community level government and sometimes a regionally representative government, sometimes not. And so how to not overtax them or not force them into all of our layers, just, you'd have to just start over with the conversation about how do we achieve the big goal? What is the goal and how do we build a system that works for both of us to get there?
Okay, so you sort of took my question, but it was sort of the same idea of the Indigenous communities are being asked to, pull up chairs. We need to pull up chairs to the table. How are we ensuring that the right representation is there? And what is that process that's going on within Indigenous communities? What's the kind of dialogue that's happening to ensure that there are the right people, I don't know if that's the right word, but that are bringing that representation that's needed for those communities? And I guess a second part or tangent, but how is this notion of Indigenous co-governance and in the context of evolving legal regimes, how is that enhancing sustainable water governance within Canada, do you think?
So, okay, I'm not sure about how to answer the first one because I'm just not entirely clear on what the question is for the first one. The second one I can start with if you'd like.
Let's start with the second one.
Yeah. So, I mean, at the end of the day, I just think that, and because I'm a governance policy type thinker person, so I kind of think if you have all the right people at the table, that at least is a better likelihood of a decision than if you're missing entire groups, right? particularly people who use the water, live in it, depend on it, let alone have rights related to it, right? Different cultures who maybe have different views of what water means, and you need all of them around the table for at least a meaningful discussion. You can't guarantee, though, you can't, that at the end of the day, the ultimate water decision is going to be better. I think it is. I've seen examples. You know, you look at the water policy, for example, I think the BC water policy is not bad, but the Northwest Territories water policy is pretty good, and it involved all Aboriginal governments in its creation, and it's got like a really solid environmental, like protective water statements in it, and the action plan flows from that. So that's an example. But I've got an interesting, also aware of a situation where there was total community control over, not Indigenous, a different situation, where local community control doesn't always mean the best decision, right? Or, you know, that kind of thing. So you just have to, I guess, work with all of the layers, and ultimately, I think you increase your chances of a better decision.
Okay. Why don't we take this opportunity then to let Merrell-Ann catch her breath, and we will thank her for a wonderful and interesting and stimulating talk. So join me in thanking Merrell-Ann, please.
Thank you.